Section 2 opens with some foreboding language, but not to fear. Execution is legalese for how a resident signs a power of attorney to create it. Termination is legalese for how a power of attorney and resident representative authority ends. And duration, not legalese, simply describes the current status of a power of attorney and the resident representative's authority. And so in this section, we will look at how a power of attorney is created and ended and learn the importance of knowing when a power of attorney takes effect. How does a resident execute, that is, have to sign a power of attorney? And it's important to know how it was done because the manner in which the resident signs the power of attorney is one of the few formalities required by law. And this inquiry has two parts. First, it is required that at the time the power of attorney is executed, the resident have had capacity to sign, to have signed it without duress or undue influence, that means of the resident's own free will, at the time the power of attorney is signed. Now, the facility will not have been present at the time of the power of attorney's execution, and so will not have direct knowledge about the resident's capacity or motivation for executing the power of attorney. So let's move to the second part, which the facility can determine the manner of signing or the ceremony that was employed. For powers of attorney that were executed before January 1, 2017, a resident simply signed the power of attorney document. It may have been signed before a notary or witnesses, but this formality was not required, except for particular transactions that you will not be concerned with. As of January 1, 2017, and thereafter, the resident must sign the power of attorney in the presence of a notary. Alternatively, it can be attested to by two or more competent witnesses who sign the power of attorney in the presence and at the request of the resident. Now, these witnesses may not be healthcare or long-term care facility owners, administrators, providers, or employees. And they may also not be related to the resident by blood, marriage, or state-registered domestic partnership. Any power of attorney that was executed on January 1, 2017 and thereafter, that was not executed in this manner, is invalid and should not be honored. And please remember that this change in law does not apply to any power of attorney signed before January 1, 2017. And it did not become invalid because it may not have been signed in front of the notary or two witnesses. It is perfectly acceptable for your purposes, and should be honored. Long-term care facility administrators may choose to exercise their discretion to seek legal advice should they have questions about the validity of any particular power of attorney. You want to find out if the power of attorney is currently in effect. Why? To understand if you must honor the resident representative's decision-making authority. A power of attorney can take effect at various points in time, and you should find out its current status before you accept and honor the representative's decisions. Generally, a power of attorney will take effect when the resident executes it, that is, signs it. But the resident may decide that it should commence at any future date, or be contingent upon the happening of some event. One event might be the resident's incapacity. A power of attorney provides a way for a resident to plan for such a time and show that a trusted person is available to make decisions on his or her behalf. If the power of attorney or the resident representative's authority is not currently in effect, then the representative has no decision-making authority. The only way to find out this information is to read the power of attorney carefully. Continuing with a look at the current status of a power of attorney, you should also want to find out how and when it will terminate. Why? Because termination will let you know the way in which the power of attorney and the authority given to the resident representative ends. And there are several ways in which a power of attorney and representative authority will end. Some of the reasons for termination are relatively straightforward and logical. The power of attorney does not survive the death of a person who created it, and the representative's authority will be extinguished upon that death. The power of attorney may have recommended the representative's appointment as a guardian, and the representative may even become an executor of the estate, But the representative's assumption of that kind of authority is subject to separate legal confirmation. The effect of the representative's death is obvious, unless the resident principal has assured that the power of attorney provides for a successor representative. A power of attorney may state how and when it terminates, or that its intended purpose may have been fulfilled. A court action may also modify or terminate a power of attorney. Additionally, actions to alter or end a marriage can also terminate a resident's representative's authority. A power of attorney will terminate where the resident and the representative are married or have a state-registered domestic partnership under the following conditions. For any power of attorney executed before January 1, 2017, the power of attorney will terminate when an annulment, dissolution, or legal separation is formally completed and the marriage or state-registered domestic partnership is legally annulled or dissolved. For a power of attorney executed on January 1, 2017, and thereafter, the power of attorney terminates when the action for annulment, dissolution, or legal separation is commenced. And please note that the resident representative's authority will be reinstated if that marital action is then withdrawn or dismissed before its completion. Long-term care facility administrators may choose to seek discretion to seek legal advice regarding the status of a resident's marriage or state-registered domestic partnership. Another form of termination is through a resident's revocation of a representative's decision-making authority. A resident who has capacity can revoke the appointment of a representative or deny a representative the ability to make any particular decision or take any action at any time by simply advising the representative verbally or in writing, say by executing a new power of attorney. But importantly, if that revocation is not communicated to someone who is relying on the representative's authority, such as facility staff, then that person may rely on the representative's authority just as if it had not been revoked. And please note this change in law as of January 1, 2017. The execution of a new power of attorney does not revoke any prior power of attorney unless that revocation is clearly stated in the new power of attorney. For practical purposes, that situation might be the same for powers of attorney executed before January 1, 2017 as well. Well, but it is not uncommon for there to be more than one power of attorney document in existence. So how should facility staff choose between the various powers of attorney? It is the resident's responsibility to inform all resident representatives and facility staff about the revocation of a prior power of attorney. The resident must have had capacity to revoke that power of attorney. It would be inappropriate for staff to honor one representative over another where the existence of two or more powers of attorney present a conflict. In the event of a conflict, it is important for long-term care facility staff to ensure that the resident's rights are protected and the resident's expressed choices and desires, written, verbal, current, and historical, are respected. Once again, administrators may choose to exercise discretion to seek legal advice if more than one power of attorney appears to be in effect. Additionally, your long-term care ombuds is knowledgeable about resident rights law and is available to provide information and support the resident in such situations. One of the more important uses for a power of attorney is for the resident to ensure that there is a representative available to handle affairs should the resident develop a disability or the inability to make appropriate decisions concerning some aspect of personal life, healthcare, or financial status. Only a resident with capacity can validly execute a POA, and a power of attorney will not survive a determination of the resident's loss of that capacity unless the resident has planned for this eventuality and included in the power of attorney language that clearly states the desire for the power of attorney to continue. And this is accomplished by using language in the power of attorney which states that it shall not be affected by the disability or incapacity of the resident, or it shall become effective upon the disability or incapacity of the resident, or other similar language may be used, so long as the intent is clear. A power of attorney that contains such direction by the resident is described as a durable power of attorney, and it continues the resident's permission for his representative to act under the power of attorney, regardless of a determination that the resident no longer has decision-making capacity.